Diana Holt had been in family court long enough to know when a case was already decided. She stood at the petitioner's table in a tailored charcoal suit, flanked by 2 junior attorneys, and let her eyes move across the aisle to the man sitting alone on the other side. Ryan Carter. No legal team. No briefcase. A worn suit jacket with a fraying collar and a single manila folder on the table in front of him. She leaned toward her associate and said quietly, but not quietly enough, that this would not take long. Then Ryan stood up and asked one question, and the room went still. Richmond, Virginia, sits in that particular part of the American South, where the summers press down like something physical, where the air conditioning units mounted in old window frames run from May through September without rest. Ryan Carter knew every one of those units. He knew the models that failed quietly, and the ones that failed loud, the brands that lasted a decade, and the ones that gave out in 3 years. He had been servicing HVAC systems across Richmond for over 15 years, and there was not a neighborhood in the city he hadn't driven through with a toolbox in the back of his truck and a work order on the passenger seat. He was 43 years old, and he looked it not in a broken way, but in the way of a man who had spent his adult life doing physical work in uncomfortable spaces. His hands were wide and calloused. The lines around his eyes had deepened over the years, but they were the kind of lines that came from squinting in bright sunlight, not from bitterness. He was not a bitter man. That was perhaps the most remarkable thing about him, given everything that had happened. The divorce had been finalized 10 years ago. Ryan and Melissa Carter had been married for 6 years before it fell apart, and when it did, the separation was handled quietly, without the kind of prolonged legal warfare that left families in ruins. Ryan had not contested much. He had not hired a team of attorneys to dismantle Melissa's credibility or fight over every asset. He had asked for one thing and received it: full custody and the right to build a stable life around that responsibility without interference. Melissa had agreed without much resistance. She had already been making plans to leave Richmond, and those plans did not appear to include a complicated custody arrangement or a life anchored to a city she wanted to leave behind. So she left. She relocated to Charlotte, North Carolina, took a position with a marketing firm, and built a new life with the kind of deliberate energy that people apply when they are trying not to look back. Ryan did not resent her for it. He understood on some level that the marriage had been wrong for both of them long before either of them admitted it. What he could not fully understand, and had chosen not to dwell on, was how easily she had walked away from everything, including the family she was leaving behind. Ryan stayed in Richmond. He stayed in the same house, a modest 2-bedroom on Westover Hills Boulevard that needed more repairs than he had time to make. He kept his truck, kept his tools, kept his job, and kept going. His income was not large. There were months when the work slowed and the bills stacked up, and he had to make decisions about which things could wait another week. He drove a truck that was 8 years old and wore clothes until they wore out. He did not take vacations. He did not spend money on things he didn't need. Everything he earned went toward keeping the house stable, keeping the utilities on, and making sure the household ran the way it needed to run. The people in Ryan's life, his co-workers, his neighbors, a few friends from his years in Richmond, often told him they didn't know how he managed it. A single father working a trade job, no family nearby to help carrying everything himself. He always gave the same answer, which was that there wasn't much to manage. You just did what needed to be done. He didn't say it to sound noble. He said it because it was true. He had never experienced his life as extraordinary. It was simply his life, and he lived it the way he knew how. He had not remarried. He had not seriously dated anyone in the 10 years since the divorce, not because he was incapable of it, but because he had made a quiet, deliberate decision that his attention and his time were not divided things. He gave what he had to the responsibilities he had taken on. That was the arrangement he had made with himself, and he had kept it without complaint. For 10 years, that arrangement had held. Then the letter arrived, It came through the mail, a formal document from a law firm based in Charlotte, addressed to Ryan Carter regarding the matter of primary custody. He read it twice, standing at the kitchen counter, still in his work clothes, his hands leaving faint smudges on the paper. The letter was written in the careful neutral language of legal correspondence, but its meaning was not neutral at all. Melissa Carter was petitioning the court to transfer full custodial rights from Ryan to herself. Ryan set the letter down. He looked at the window above the sink at the late afternoon light coming through it, and he stayed very still for a long moment. Then he folded the letter, put it back in the envelope, and set it on the counter while he washed his hands. He called Melissa that night. She answered on the second ring, and her voice was the composed, measured voice of someone who had rehearsed for this conversation. She told him she had been doing a lot of thinking. She told him that she was in a better place now, financially, professionally, personally. She said she believed the current arrangement deserved to be reconsidered, that she could now offer a different kind of stability, the kind that Ryan, through no fault of his own, simply could not provide. She said it without cruelty, but she said it clearly. Ryan listened. He asked her one question: had anyone expressed that they wanted this change? Melissa's answer was careful. She said that fuller information changes what options feel available, and that she believed the time had come to let those options be considered. Ryan recognized that as a non-answer. He did not push. He told Melissa he understood what she was saying, and that he would respond through appropriate channels. Then he ended the call. He sat at the kitchen table for a long time after that. The house was quiet. He thought about the years not in a sentimental way, not with the kind of retrospective tenderness that softens memory into something easier to carry, but honestly. He thought about the school mornings and the sick days and the budget calculations he had done at this same table. He thought about every decision he had made with one purpose: to keep things steady. And now, a woman who had spent the last 10 years building a life somewhere else was asking a court to determine that his version of steady was not good enough. He called 3 law firms the following week. The first 2 didn't return his calls. The third one did, and the attorney he spoke to was direct a contested custody case involving an existing arrangement with the other party represented by an established firm would cost somewhere between $15,000 and $30,000, depending on how long it ran. Ryan thanked him and ended the call. He sat with that number for several days. $15,000 was not a number he had access to. He had savings a few thousand set aside for emergencies, and those savings existed because he had spent 10 years being careful. But they were not a legal defense fund. He talked to people he trusted. A co-worker suggested he accept a compromise, agree to a shared arrangement, split the time, avoid the fight. A neighbor who had been through her own divorce told him that family courts tended to favor financial stability, and that he should be realistic about how a judge would see his situation. Even his supervisor at work, a decent man who had known Ryan for years, told him gently that sometimes you had to pick your battles. Ryan heard all of it. He sat with all of it. And then he made a decision that surprised everyone who knew him, though it did not surprise him. He was not going to agree to a transfer of custody. He was not going to negotiate terms that reduced his role to that of a scheduled visitor. And he was not going to walk away from a fight because he couldn't afford the entrance fee. If Melissa wanted to bring this to court, then court is where they would settle it, and he would stand there himself without a lawyer and make his case. People told him that was a mistake. They told him family court was complicated, that judges didn't respond well to self-represented litigants in contested cases, that the other side had professionals who knew exactly how to dismantle an argument. Ryan acknowledged all of that. He spent the following weeks at the public library reading case law and procedural guides, working through the court's self-help resources, taking notes in a spiral notebook he carried with him everywhere. He was not a legal expert. He was not going to pretend otherwise. But he understood the facts of his own life, and he understood what he was fighting for, and he had decided that those 2 things together were enough to stand on. The first time he walked into the courthouse to file his response, The clerk at the intake window looked at him carefully and asked if he had legal representation. He said he was representing himself. She handed him the appropriate forms without comment. He filled them out at the counter, checked his work twice, and submitted them. On the way back to his truck, he passed a row of attorneys in suits, walking in the opposite direction, briefcases in hand, talking to each other without looking up. He didn't slow down. He had work to get back to. The hearing date was set for 6 weeks out. Melissa's legal team, Diana Holt, leading 2 junior associates assisting, filed a series of preliminary motions in the weeks that followed. Ryan responded to each one in writing carefully, using language he had spent time learning to understand. He was not fast, he was not elegant, but he was thorough, and he was accurate, and he did not miss a single deadline. The night before the hearing, Ryan sat at the kitchen table with his documents spread out in front of him and went through everything one more time. The financial records, the maintenance logs for the house, the documentation he had assembled over 10 years that showed in plain terms what his life actually looked like from the inside. He didn't have a strategy built on legal maneuvers. What he had was a record. A clear, consistent, unambiguous record of a man who had shown up every day for 10 years without asking for recognition or help or relief. He closed the folder. He looked at the chair across the table, the one that had been there for years, positioned the way it always was. He thought about what was at stake, not in abstract terms, but in the specific, concrete terms of daily life. The morning routines, the drive to school, the dinners he made from whatever was in the refrigerator, the ordinary architecture of a life that someone was now asking a judge to dismantle. He was not going to let that happen without saying something. He was not going to let it happen without standing up and being counted. He went to bed at 10 o'clock. He set his alarm the same way he did every morning. And in the morning, he put on his best suit, the one with the fraying collar that he had worn to exactly 3 occasions in the last decade, and he drove to the courthouse. The courtroom was smaller than Ryan had expected. He had built it up in his mind during the weeks of preparation, imagined something formal and imposing with high ceilings and the kind of weight that made people lower their voices when they walked in. The reality was a standard civil courtroom on the 4th floor of the Richmond courthouse, fluorescent lighting rows of wooden benches, and a smell of old paper and floor cleaner that reminded him of the public library, where he had spent so many evenings studying for this. He took his seat at the respondent's table, set his folder down in front of him, and looked straight ahead. Diana Holt and her team arrived 3 minutes before the session opened. She moved through the courtroom with the ease of someone who spent most of her working life in rooms like this one. Her 2 associates arranged documents with practiced efficiency while she stood and reviewed something on her phone unhurried. She did not look at Ryan. That was, he understood, a deliberate choice, not rudeness, but the kind of studied indifference that communicates a position before a single word is spoken. He was not worth the attention of a preliminary glance. He was already accounted for. Before she sat down, she leaned toward her associate and said something he couldn't fully hear, but the tone of it was clear enough. Quiet. Confident. The tone of someone who considered the outcome settled. Judge Harold Warren entered, and the room stood. He was a man in his early 60s, with a careful, measured demeanor that gave away nothing. He reviewed the case documentation for a moment before signaling for the session to begin. Diana Holt rose first, and what followed was a presentation that Ryan had to acknowledge privately was extremely well constructed. She did not attack him personally, not directly, not at first. She built her argument the way a structural engineer builds a load-bearing wall, systematically, methodically, one layer at a time, each piece supporting the next. She began with Melissa's circumstances, the position she held at a communications firm in Charlotte, the trajectory of her career over the last decade, the stability and size of her current income. She presented documentation, tax returns, employment records, letters from her employer that painted a clear picture of a woman who had used the years since her divorce to build something substantial. Then she turned to the question of environment, And here, her language became more careful, more deliberate, more pointed. She spoke about the difference between what was adequate and what was optimal. She spoke about the kinds of opportunities that different financial circumstances made available or unavailable. She never said Ryan was a bad father. She said with precise legal language that his circumstances placed inherent limitations on what he could provide, and that the court had an obligation to weigh those limitations against what was possible. Ryan wrote 2 words in the margin of his notepad: inherent limitations. He underlined them once and kept listening. The financial examination that followed was thorough, and from Ryan's perspective, not inaccurate. Diana Holt submitted his income records for the last 3 years, his mortgage statements, his monthly utility costs, a summary of his outstanding debts. She walked the court through each document with the calm efficiency of someone presenting evidence that speaks for itself. Ryan's annual income from his HVAC work averaged $41,000. His mortgage payment, utilities, insurance, and basic household expenses consumed the majority of it. What remained was not negligible, but it was not the kind of financial cushion that suggested comfort or flexibility. When she was finished, she had not fabricated a single number. Everything she presented was accurate. That was what made it effective. She had taken the true facts of his life and arranged them to tell a story that he barely recognized as his own. Judge Warren looked up from the documents and turned to Ryan. He asked if he had any immediate response to the financial exhibits. Ryan stood and said he did not dispute the numbers. He said the numbers were correct. He said he would address the context in which those numbers existed when it was his turn to present. The judge nodded and made a note. The morning session continued. Diana Holt called Melissa to the stand, and Melissa testified with the composed, articulate confidence of someone who had spent time preparing. She spoke about her current life in Charlotte, the apartment she had purchased, the neighborhood, the professional community she had built around herself. She spoke about what she believed she could offer that had not previously been available. She was careful to avoid direct criticism of Ryan. She said things like, "I'm not questioning his commitment, and I have enormous respect for what he's done," before pivoting each time to the argument that commitment alone was not sufficient, that respect for effort did not obligate the court to ignore the question of what was possible. Ryan watched her from across the room. She was 41 now, and she carried herself with the kind of assurance that came from years of professional success. He did not feel animosity toward her. What he felt was something more complicated and harder to name, a recognition that the woman speaking from the witness stand was someone he had once known very well, and that the person she had become was largely a stranger to him, shaped by a decade of choices made in a city he had never visited. When Diana Holt finished her direct examination, Ryan rose to cross-examine. He had prepared questions, careful ones, written out in his notebook, reviewed and revised over several evenings. He asked Melissa about her contact with the household over the preceding 10 years. He asked her to describe specifically how many times she had visited Richmond in that period. He asked her to characterize the nature and frequency of her communication with her own family. He kept his voice level and his manner neutral. He was not trying to humiliate her. He was trying to create a record. Melissa answered each question carefully, and her answers, when laid out in sequence, described a decade of minimal presence, not zero, but minimal. Ryan thanked her and sat down. He did not editorialize. He let the answers exist in the room without commentary. The afternoon session brought a harder problem. Diana Holt shifted her focus from documentation to narrative, and here she was most effective. She began drawing a picture not just of what Ryan lacked, but of what Melissa represented: possibility, growth, a wider world. She argued carefully but unmistakably that maintaining the status quo was not the same as serving the best interests of the people involved, and that courts existed precisely to make that distinction when parents could not. She acknowledged Ryan's decade of sole caregiving. She called it commendable. Then she asked the court to consider whether commendable was the same as optimal, and whether the law required them to accept one when the other was available. Ryan had expected this argument. He had read versions of it in the case law he had studied at the library. But reading it in case summaries and hearing it spoken aloud in a room where it applied to his life were different experiences. He kept his face neutral. He wrote in his notebook. He did not react. What he had not fully anticipated was how the day's cumulative effect would register on Judge Warren. The judge's questions when he interjected were focused and precise, and several of them pushed in directions that suggested he was genuinely weighing the financial dimension of the case. He asked Diana Holt whether her client's petition was based primarily on the financial differential between the two households. She said it was one significant factor among several. He asked Ryan whether he disputed that a financial differential existed. Ryan said he did not dispute it. The judge made another note and moved on. But Ryan had seen something in the exchange that settled in his chest like a stone. The court was taking the money seriously. More seriously than he had wanted to believe it would. That evening, Ryan drove home and sat at the kitchen table with his notebook open in front of him. He had never told anyone, not his co-workers, not his neighbors, not the attorney he had briefly spoken to on the phone, about what he had discovered during the final year of his marriage. He had found out in a way that left no ambiguity, and what he had done with that knowledge was nothing. He had made a deliberate decision at a moment when he could have weaponized the truth not to. He had told himself it was to keep the proceedings clean, that he didn't want a divorce that turned into a public exposure of private failures. He had told himself that the clean ending was better for everyone, and in the years since he had kept that decision and never revisited it. Sitting at the table that night for the first time in 10 years, he revisited it. He thought about the afternoon of the discovery. A weekday, his work schedule had changed unexpectedly. He had come home early. He thought about what he had seen, what he had understood, and the particular quality of the silence that had filled the house in the days that followed while he decided what to do. He had never confronted Melissa directly. He had said only that the marriage was finished, that he wanted to proceed with the separation as cleanly as possible, that he was not interested in assigning blame in legal documents. Melissa had agreed, and her agreement had been immediate enough to tell him everything he needed to know about whether she had wanted the marriage to continue. When the asset division was negotiated, Ryan had accepted an even split. Half of the shared savings, half of the equity in the house, each of them taking the vehicle they drove. He had not asked for more, even though he knew, and she knew, that he could have. The infidelity would have shifted the terms. In Virginia, the circumstances of a marriage's dissolution could influence the distribution of marital assets. He had chosen not to use that leverage. He had accepted the even split and let her go, and he had never told a single person why. Now the woman he had protected from that exposure was standing in a courtroom asking a judge to overturn 10 years of established custody on the grounds that he didn't make enough money. He sat with that for a long time. He was not angry, exactly. The emotion he felt was more precise than anger. It was a recognition of a particular kind of irony, the kind that didn't make you want to laugh, but made you very, very clear about what you were willing to do next. He had stayed silent 10 years ago to protect everyone, including her. He had chosen peace over leverage, and that choice had cost him nothing until now. Now, it had potentially cost him everything. The second day of the hearing opened with Diana Holt introducing what she called a comprehensive assessment of the respondent's living situation. She had obtained, through legal process, a summary of the maintenance history of Ryan's house on Westover Hills Boulevard. She noted that the property had several deferred repairs, a section of roof that needed attention, an HVAC unit that Ryan had patched repeatedly rather than replacing, plumbing in the second bathroom that had been non-functional for the better part of 2 years. She presented this as evidence of a household operating in a state of ongoing material deficiency. She did not overstate it. She simply presented it and let Judge Warren draw his own conclusions. Ryan watched the judge read through the maintenance summary. He saw the moment when Warren's eyes moved from the document to him, a brief assessing glance, and then back to the document. It was a small thing, lasted less than 2 seconds, but it told Ryan that the judge was no longer entirely neutral, that the accumulated weight of what Diana Holt had presented over 2 days was doing exactly what it was designed to do. At the lunch recess, Ryan sat alone in the hallway outside the courtroom on a wooden bench. A few attorneys passed him, talking to clients or into phones. Nobody acknowledged him. He ate a sandwich he had brought from home, the same lunch he packed on workdays, and reviewed his notes from the morning. He had responses prepared for most of what had been presented. He could address the house, maintenance, explain each deferred repair in the context of prioritization, provide documentation of the repairs he had made, and the timeline of the ones still pending. None of that was fabricated. It was all true and defensible. But he understood, sitting on that bench with his sandwich and his notebook, that defensible was not the same as winning. The afternoon brought the moment that Ryan would later think of as the edge, the point passed, which if nothing changed, the outcome was no longer uncertain. Diana Holt made her closing statement for the day with a clarity that stripped away any remaining ambiguity about what she was arguing. She said that the court had before it a clear choice, a parent who, despite genuine love and genuine effort, was operating at the edges of what his circumstances allowed, and a parent who had built a stable, expanding life with the resources to offer something meaningfully different. She said the court's obligation was not to reward effort, but to serve the future of the people involved. She said it without malice, and that was the worst part because it didn't sound like an attack. It sounded like reason. Judge Warren looked at Ryan and told him he would have the opportunity to make his full statement at the next session. He said he wanted to ensure the respondent had adequate time to present his position comprehensively. His tone was courteous and entirely unreadable. Ryan thanked him and said he would be prepared. Walking out of the courthouse that evening, Ryan passed Diana Holt in the corridor. She was speaking to one of her associates and didn't see him or chose not to. He did not slow down. He walked to his truck, put his folder on the passenger seat, and drove back to Westover Hills. The sun was going down over Richmond, cutting long shadows across the road, and he drove through them, thinking about one thing, only what he was going to say when it was finally his turn to stand up and speak. He had one decision left to make, and he already knew what it was. The third and final session opened on a Tuesday morning, and Ryan arrived early. He was there before the clerk unlocked the courtroom doors, sitting on the wooden bench in the hallway, with his folder on his knees and his hands resting flat on top of it. He had not slept well. He had not expected to. He had spent most of the night at the kitchen table, but this time he wasn't reviewing documents or rehearsing arguments. He was thinking about a Tuesday afternoon 10 years ago, and what he had walked into, and the decision he had made in the days that followed. He had turned it over carefully, the way you turn over a tool to check its condition before you use it. And by the time the sun came up, he had made his peace with what he was going to do. Diana Holt arrived with her team at 8:55. She moved through the corridor without looking at the bench where Ryan was sitting, and he did not call out to her. There was nothing to say in a hallway that hadn't already been said in the courtroom, and what remained to be said belonged in there in front of Judge Warren on the record. When the session opened, Judge Warren reviewed his notes from the previous 2 days before addressing the room. He said he wanted to give the respondent the full opportunity to present his position and that he had set aside the morning for that purpose. He looked at Ryan and said he could proceed whenever he was ready. Ryan stood, buttoned his jacket once out of habit, and walked to the front of the room. He did not have a presentation prepared in the way Diana Holt's had been prepared. He had no slides, no printed exhibits arranged in a binder, no associates to pass him documents on cue. What he had was his notebook, his folder, and the decision he had made in the early hours of the morning. He set the folder down on the edge of the respondent's table and left it there. He did not open it. He began by telling the court that he was not going to dispute the financial picture that had been presented over the previous 2 days. He said the numbers were accurate and the documentation was legitimate, and he had no interest in contesting facts. He said he understood why those facts arranged the way they had been arranged, told a particular story, and that he thought it was important to tell the court a different story, not by contradicting the evidence, but by providing the context that the evidence on its own could not carry. He spoke for several minutes about the life he had built in Richmond over the past 10 years. He described it plainly, without sentiment, the way a man describes something he knows well: the work schedule, the household management, the decisions he had made about money and time and priority. He did not ask the court to be moved by it. He presented it as information the way he had been watching Diana Holt present information for 2 days, and he kept his voice level and his manner composed. He could feel the room listening. Not sympathetically, not yet, but attentively, which was what he needed. Then he stopped. He looked down at the folder on the table, and he told the court that there was something he had not previously disclosed, something that had no direct bearing on the financial arguments that had been made, but that he believed had everything to do with the question the court was actually being asked to answer, which was not whether Melissa Carter had more money than Ryan Carter, but whether this petition was genuinely about what was best for the family, or whether it was about something else entirely. He told them about the infidelity. He did it without drama and without detail beyond what was necessary. He said he had discovered during the final year of his marriage that Melissa had been involved with another person. He said he had not confronted her in the way some men might have. He had not hired a private investigator or gathered documentation or consulted an attorney about how to use the information. He had simply decided, in the days after the discovery, that he was not going to build the end of his marriage on an act of exposure. He said he had made that choice for one reason. Above all, he did not want the legal record of his marriage's end to be something that followed everyone involved for the rest of their lives. The courtroom was very quiet. Ryan did not look at Melissa while he spoke. He kept his eyes on Judge Warren, who had set down his pen and was listening with an expression that gave nothing away, but suggested everything was being registered, not on paper, but somewhere more permanent. Ryan said that when the asset division was negotiated, he had accepted an even split. Half of the shared savings, half of the equity in the house, each of them taking the vehicle they drove. He said he was aware at the time that Virginia law regarding the circumstances of a marriage's dissolution could have influenced that division in his favor. He said he had chosen not to pursue that advantage. He said Melissa had received half of everything they had built together, and he had accepted that outcome, and he had never told anyone, not a friend, not a coworker, not an attorney, what he knew or what he had given up by staying silent. He said he was telling the court now not to punish Melissa or to reopen a settlement that had been finalized 10 years ago. He was telling the court because he wanted it to understand who was standing on each side of this case and what each of them had actually chosen when the choosing was hard. He turned then for the first time since he had begun speaking and looked directly at Melissa. She was sitting at the petitioner's table with her hands folded in front of her, and she was very still. Diana Holt beside her had the controlled expression of an attorney processing an unexpected development and deciding in real time how to respond to it. The 2 junior associates had stopped writing. The room had the particular quality of silence that comes not from emptiness, but from a large number of people choosing simultaneously not to make a sound. Ryan looked at Melissa for a long moment. Then he asked her the question. "In all the years since you left," he said, "did you ever once make a decision with this family in mind? Or was every decision you made about building the life you wanted for yourself?" The question landed in the room and stayed there. Melissa did not answer immediately. Her face did not collapse. She was too composed for that. But something shifted in it, some careful calibration she had been maintaining for 3 days, and the shift was visible enough that several people in the gallery could see it. Diana Holt leaned toward her client and said something quietly. Melissa straightened slightly and looked at the table in front of her, rather than at Ryan or the judge. Judge Warren did not press her to answer. The question had not been posed as formal cross-examination. Ryan was in the middle of his own statement, not conducting a procedural examination of a witness. But the question existed in the record now, and its existence changed the texture of everything that had come before it. It reframed the entire preceding 3 days, not as a financial comparison between two households, but as a question about character and motivation that no tax return could answer. Ryan turned back to face the judge. He said he was not asking the court to punish Melissa for the past. He said he was not standing there to settle scores or to use old pain as a legal weapon. He said he understood that courts were not in the business of adjudicating who had been wronged in a marriage, and he was not asking for that judgment. What he was asking for was something simpler, that the court look at the full picture of what had actually happened over the past 10 years, rather than the partial picture assembled from financial documents, and make a decision based on that complete record. He said that his house needed repairs. He said that was true, and he was not going to pretend otherwise. He said he drove a truck that was 8 years old and wore a suit with a fraying collar and ate sandwiches he packed himself because he had spent 10 years making sure the money went where it needed to go. He said none of that was evidence of failure. He said it was evidence of a specific set of choices made by a specific kind of person, and that he would make every one of those choices again without hesitation. He picked up the folder from the table. He opened it and removed a single document, a calendar he had printed from his records, covering 12 months with handwritten notations throughout. He submitted it as an exhibit and passed a copy to Diana Holt and a copy to Judge Warren. It was a record of his work schedule set alongside a record of every appointment, every commitment, every obligation that had required him to be present and accountable. The notations showed across 12 months how he had arranged his professional life around those personal obligations, which jobs he had moved, which over time he had declined, which early mornings and late evenings he had restructured to make everything fit. He told the court that the document covered 1 year, but that the same pattern extended across all 10. He said if the court wanted records from additional years, he had them. Judge Warren looked at the calendar for a long time. He turned to Diana Holt and asked whether she had any response to the respondent's statement regarding the circumstances of the prior marriage. Diana Holt stood and said that her client's petition was based on current circumstances and future considerations, and that events from 10 years prior were outside the scope of the modification proceedings. The judge acknowledged that and said he appreciated the clarification. His tone remained entirely neutral, but he wrote something in his notes that took longer than his previous notations had taken, and Ryan watched the pen move without being able to read what it said. The closing arguments that followed were brief. Diana Holt maintained her position with professionalism. She had been hired to make a case, and she made it to the end without visible frustration. She acknowledged the respondent's statement said it did not alter the financial realities before the court, and asked Judge Warren to rule in her client's favor on the basis of what was demonstrably available to each party going forward. Ryan made no formal closing argument. He said only that he had told the court everything he had to say, and that he trusted the court to weigh it honestly. Judge Warren recessed for 40 minutes. When he returned, he settled into his chair and looked at both tables before he spoke. He said that family court cases involving the modification of existing custody arrangements required the petitioning party to demonstrate that a material change in circumstances had occurred and that the proposed modification served the best interests of those involved, not the preferences of either parent, not the financial aspirations of either party, but the genuine welfare of the family at the center of the case. He said the court had heard substantial documentation regarding the financial differential between the two households, and he acknowledged that differential as real and significant. He said financial stability was a legitimate consideration. He said it was not, however, the only consideration, and in many cases, it was not the determinative one. He said that what the court had also heard in the respondent's statement in the cross-examination record from the previous sessions and in the pattern established by the calendar exhibit was a decade of consistent, demonstrable daily presence and accountability on the part of the respondent. He said that consistency carried weight in family court and that weight was not abstract. He said that disrupting an established and functioning home required a compelling reason rooted in genuine welfare, and that the petitioner had not demonstrated such a reason to the court's satisfaction. The financial differential, while real, did not constitute a material change sufficient to justify the modification being requested. He denied Melissa Carter's petition. He ordered that primary custody remain with Ryan Carter. He said the existing arrangement regarding the petitioner's visitation rights remained in effect, and that either party was free to return to the court in the event of a genuine material change in circumstances. He thanked both parties for their conduct during the proceedings and adjourned. The sound in the room after the gavel came down was not dramatic. There was no outburst, no visible celebration, no moment of cinematic release. Ryan stood at his table with both hands resting on the edge of it and looked at the middle distance for a moment. Then he gathered his folder, his notebook, and the copy of the calendar exhibit and put them together carefully. Across the aisle, Diana Holt was already leaning toward Melissa, speaking quietly. Melissa was not looking at Ryan. She was looking at the table in front of her, and her face had the quality of a person who is not going to lose composure in public, but is spending real effort to maintain that. Ryan did not go to her. What had needed to be said had been said in front of a judge on the record in the room where it mattered. There was nothing left to add. He walked out of the courtroom and into the corridor. He sat down on the same wooden bench where he had waited that morning, his folder on his knees, his hands flat on top of it, exactly the same position as when the day had started. The courthouse moved around him, footsteps, doors, the distant sound of other people's proceedings, and he sat in the middle of it and let himself be still for the first time in weeks. After a while, he stood up, put on his jacket, and walked to the elevator. He rode down to the ground floor, walked out through the main entrance into the Richmond afternoon, and crossed the street to the parking garage. He found his truck on the second level, unlocked it, and set his folder on the passenger seat. He sat behind the wheel for a moment without starting the engine. Then he started it, pulled out of the garage, and drove toward Westover Hills. In the ordinary light of an ordinary Tuesday, a man with work to get back to a house that still needed fixing and nothing left to prove to anyone. Several weeks after the ruling, Melissa reached out. Not through her attorneys. The call came directly from her personal number on a Sunday evening. It was a short call. She did not apologize in the formal sense, and he did not expect her to. She said she had been thinking about what he had said in the courtroom. She said she understood now that there were things she owed that she had not yet paid, and that a courtroom was the wrong place to try to pay them. She asked if there was a path forward that didn't require lawyers to arrange it. Ryan told her there was. He told her that the door had never been closed from his side, that it had always been her choice, how often she walked through it, and that the same remained true. He said only that anything going forward had to be built around what was genuinely right for the family, without negotiation, without condition, and without a legal filing as the motivation. Melissa said she understood. The call ended. Ryan set his phone on the counter and went back to what he had been doing, making dinner in his kitchen, in his house on Westover Hills Boulevard, on a Sunday evening, the same as any other. The roof still needed fixing. The second bathroom was still waiting on the plumbing. His truck had crossed 90,000 miles and would need attention before winter. None of it had changed. He had not won a prize or been handed a different life. He had simply kept the life he had, which was the only thing he had ever been fighting for. He turned the burner down, checked the time, and went to set the table.